Assalamualaikum and greetings to Sir Syafiq Sulaiman. My name is Nur Najah binti Adnan and I will be presenting the topic of crimes against humanity for my blog post or e-portfolio assignment. We'll be starting with the introduction part where I explain the definitions of crimes against humanity. The definition of crimes against humanity is codified in Article 7 of the Rome Statute of the International Criminal Court (ICC). The notion encompasses crimes such as murder, extermination, rape, persecution, and all other inhuman acts of the similar character, willfully causing a great suffering or serious injury to body or to mental physical health, committed as part of a widespread or systematic attack directed against civilian population with knowledge of the attack. These criminal acts, which are committed by or on behalf of a de facto authority, usually by or on behalf of a state, that grossly violate human rights. Unlike war crimes, crimes against humanity do not have to take place within the context of wars, and they apply to widespread practices rather than acts which are committed by individuals. And all the crimes against humanity apply to acts which are committed by or on behalf of authorities. They do not need to be part of the policy, and they only need to be tolerated by the authority. So, the first prosecution for crimes against humanity took place during the Nuremberg trials. The notions of crimes against humanity has evolved under international customary law and through the jurisdiction of international courts such as International Criminal Court, the International Criminal Tribunal for the former Yugoslavia, and the International Criminal Tribunal for Rwanda. Many states have also criminalized crimes against humanity in their domestic law, and others have yet to do so. Unlike genocide and war, crimes against humanity have not yet been codified in a dedicated treaty of international law. Despite this, the prohibition of crimes against humanity, similar to the prohibition of genocide, has been considered a peremptory norm of international law from which no derogation is permitted and which is applicable to all states. Referring to the Article 7 of Rome Statute of the International Criminal Court regarding crimes against humanity, for the purpose of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack. A. Murder. B. Extermination. C. Enslavement. D. Deportation or forcible transfer of population. E. Imprisonment of or other severe deprivation physical liberty in violation of fundamental rules of international law. Torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, or any other form of sexual violence of comparable gravity. And the list goes on to the crime of apartheid. From the paragraph 1, A, the attack directed against any civilian population means a coarse conduct involving the multiple commission of acts referred to in paragraph 1 against any civilian population, pursuant to or in furtherance of a state or organizational to commit such attack. Now, I will explain the element of crimes, which according to Article 7, paragraph 1, which we can refer to the Rome Statute of the International Criminal Court, crimes against humanity do not need to be linked to an armed conflict and can also occur in peacetime, similar to the crime of genocide. And the same article provides a definition of the crime that contains the following main elements, which are the mentioned before, from murder up to the other inhuman acts. And the contextual element is when committed as part of a widespread or systematic attack directed against any civilian. And as for mental element, which is with knowledge of the attack. The contextual element determines that the crimes against humanity involve either large-scale violence in relation to the number of victims or its extension over a broad geographic area, which widespread, or a methodical type of violence, which is systematic. This excludes random, accidental, or isolated acts of violence. In addition, which we can refer to the Article 7, paragraph 2A of the Rome Statute, which mentioned that it determines that crimes against humanity must be committed in furtherance of a state's or organizational policy to commit an attack. The plan or the policy itself does not need to be explicitly stipulated or formally adopted and can be inferred from the totality of the circumstances. This is in contradiction with genocide, whereas the crimes against humanity do not need to target a specific group. Instead, the victim of the attack can be any civilian population, regardless of its affiliation or its identity. And another important distinction is that in the case of crimes against humanity, it is not necessary to prove that there is an overall specific intent. And it's sufficient for there to be a simple intent, just only intent to commit any of the acts listed. And with the exception of the act of prosecution, which requires additional discriminatory intent, the perpetrator must also act with knowledge of the attack against the civilian population and that his or her action is part of the attack. This part I will explain the historical background of the crimes against humanity. So in 1946, the concept of crimes against humanity had already been endorsed by the United Nations General Assembly, and it has been evolving since World War II. The content of crimes against humanity, through the jurisprudence of ICTY and ICTR, along with the establishment of ICC. So the statutes of international tribunals had reflect the crimes against humanity as they existed under the customary international law. So, however, there are some differences that differentiates the contextual requirements for crimes against humanity in the statutes of the various international tribunals. And we can see the establishment of the international community, which from the international community in 1990s, the ad hoc tribunals that were established in order to prosecute the perpetrators of crimes against humanity as well as the war crimes in genocide. And that includes both of the ICTY and ICTR, or known as the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. Unlike these previous tribunals, ICTY and ICTR includes rape and torture in the list of crimes against humanity. So, referring to Article 5 of the ICTY and Article 3 of the ICTR, in which has stated in the International Tribunal shall have power to prosecute persons that responsible for the following crimes that committed in armed conflict, whether international or internal in character, and directed against any civilian population. So the said crimes are murder, extermination, enslavement, deportation, imprisonment, torture, rape, prosecutions on political or racial and religious grounds, and other inhuman acts. And as for the thing that I mentioned before is during the ICTY and ICTR. And now it has been adopted in the ICC Article 7, International Criminal Court, which is from the Rome Statute. For the purpose of the statute, crimes against humanity means any of the following acts committed as part of a widespread or systematic attack directed against any civilian population with knowledge of the attack, which is the crimes are murder, extermination, enslavement, deportation or forcible transfer of population, imprisonment or other severe deprivation of physical liberty, and violation of fundamental rules in international law, torture, rape, sexual slavery, enforced prostitution, forced pregnancy, enforced sterilization, and other forms of sexual violence of the comparable gravity. Prosecution against any identifiable group or collectively on political, racial, national, ethnic, cultural, religious, gender as defined in the paragraph 3 or other grounds that are universally recognized as impermissible under the international law in connection with any act referred to this paragraph or any crime within the jurisdiction of the court. And next is enforced disappearance or of persons, the crime of apartheid, and last one is inhuman acts of a similar character intentionally causing great suffering or serious injuries for mental and physical health. In order for a crime to be recognized as a crime against humanity, it must fill the elements of crimes against humanity, in which the first one is the accused commits a prohibited act, and second is that is part of an A attack, B which is widespread or systematic, and C directed against any civilian population. And third is and when there is a link or nexus between the acts of the accused and the attack. The ICTY stated requires that the attack be committed in the context of armed conflict. However, in the case of the court in ICTY's case, Dusko Tadid held that under that customary international law, a connection with an armed conflict is not required. Meanwhile, ICTR stated requires that the attack of discriminatory element. And at the ICC, neither of these additional elements is required. As for this part, I will be explaining the one of the crimes against humanity, which is attack. So the example of case that will be used as a reference is John Paul Akaisu case number ICTR trial judgment that was held in 1998 September. So the court stated that a person commits a crime against humanity when he or she commits a prohibited act that forms part of an attack. So there are a few factors that can be considered while in the process of determining whether the attack against the civilian population has taken place. So the factor is first, are there discriminatory measures imposed by the relevant authority? And the second, was there an authoritarian takeover of the region where the crimes occur? And did the new authority in fact establish governmental structures? And next is, did summary arrest, detention, torture, rape, sexual violence, or other crimes take place? So the concept of attack and military attack differ. Crimes against humanity can occur even there is no armed conflict happens. Thus, attack is not limited to the conduct of armed hostilities or use of armed forces. So attack can also be precede, outlast, or continue during an armed conflict without necessarily being part of it. So the attack does not need to involve any military violence, in which can be referred to Akaisu's case. And ICTY and ICTR jurisprudence and the Rome Statute provide that there will be at least multiple victims or acts to be considered an attack directed against a civilian population, refer to the decision of a case Kunarak and Miloret. So at the ICC, an attack is a campaign or operation carried out against a civilian population. In the terms of directed against any civilian population, and in ICTY, it is stated that if it's directed against, it requires that the civilian population must be the primary target of the attack and not just an incidental target. So the primary object of the attack or any civilian population, referring to Kunarak case, the terms any highlights to the fact that the crime against humanity can be committed against both enemy nationals and crimes by state-owned subject. This differs to the case of Dusko Tadic, which is civilian, refers to non-combatants and population. refers to a larger body of victims in crimes of a collective nature. So, this concluded that it does not require the entire population of an area to be targeted to be considered as crimes against humanity, and that certain number of individuals of the targeted in the course of attack or individuals were targeted in a such way is enough to show that it is crimes against humanity that is happening. There are few determining factors whether the attack was directed against the civilian population. That includes the means and methods used in the course of the attack. Secondly, the number of victims or the status of victim. And the third one is the discriminatory nature of the attack. For example, the nature of the crimes committed in the course of the attack. And next is the resistance to the assailants at the time and the extent of which the attacking force may be said to have complied or attempted to comply with the precautionary requirements of the laws of war.